Assalamualaikum warahmatullahi wabarakatuh. My name is MARHA Khaleeda binti Muhammad NIZAM, metric number 2311314. Today, me and ERSALINA is going to present on the case ALW Car Workshop Sendirian Berhad and AXA Afin General Insurance Berhad 2019 MLJU 567.
I am ERSALINA ZAHIYAH binti ERWANDEY with metric number 2311298, and I'm going to start with the facts of the case. The appellant, which is the insured, who owned and operated a car repair workshop, had purchased a fire insurance policy from the respondent, which is the insurer, under the Motor Repairers Protection Plan policy. The policy provided fire coverage for the workshop with a maximum insured sum of 1.4 million ringgit. On the 21st May 2013, a fire broke out at the workshop, destroying the premises and some insured items. Following the incident, the insured sought indemnity from the insurer for the losses. On 24th June 2013, the insured submitted an initial claim totaling over 1.6 million, and the next day, the insured submitted a reverse claim for over 1.7 ringgit to reflect the losses and damages caused by the fire. However, by a letter dated 4th March 2014, the insurer repudiated liability, asserting that the claim was grossly exaggerated and fraudulently submitted. The issues are whether an insurer is entitled to repudiate liability based on an exaggerated claim when the claim is later amended to a lesser amount in the absence of proven actual fraud, and whether, in cases where an allegation of an exaggerated or inflated claim is made, actual fraud in the contractual sense must be proven in the usual manner by the party making the allegation. The arguments made by the appellant in terms of the effect of amendment to statement of the claim, where the amendment looks back to the date of the original claim, and since the court allowed the amendment, the court and the parties must treat the claim as 237,000 ringgit and not any lesser sum. Therefore, the exaggerated claim was extinguished by the amendment, and once the amendment is allowed by the court, when the insurer did not challenge the amendment by appealing it, he cannot rely on it as a defense of exaggerated claim. In terms of presumption of fraud, there is no presumption of fraud as no legal authority support a presumption of fraud based on an exaggerated claim, and the burden of proving fraud lies on the party alleging it. An inflated claim does not give rise to a presumption of fraud unless there is intent to deceive. So creating a presumption of fraud sets a dangerous precedent and conflicts with established legal principles. In terms of the requirement to prove intent to deceive, in this case, fraudulent claims need proof of intent to deceive the insurer into paying more than what is due. The insured claims and the adjuster assessment made it insufficient to establish fraud, and the Court of Appeal made a mistake by presuming fraud without proving it first. In terms of lack of dishonesty by the insured, basically the disagreement in the claim was because of a misunderstanding, yet not dishonesty of the insured, where the insured classified the damaged vehicles incorrectly, but then he did not intend to commit a fraud, and the insured fully cooperated with his adjuster, providing access to promises and documents. The adjuster actually had the chance to clarify the classification issue, but they failed to do so. In terms of loss and risk were genuine, there is no dispute that the insured suffered actual losses covered by the policy, and the insured did not fabricate and falsely claim losses but merely misclassified certain claims. Next is the arguments by the respondents, where the Court of Appeal found that the insured claim was inflated and it was reduced by 80% to 90% just before the trial, showing that it was grossly exaggerated. The insurance policy governed by the Contracts Act, where in Section 17 is the definition of fraud, which does not require proof of actual fraud as claimed by the insured. However, the insured submitted false statements in their claims, which constitutes fraud. The court ruled that the insured submitted fraudulent statements, and it aligns with the Contracts Act and the insurance policy's claims condition. Despite reducing the claim amount, the insured attempted to defraud the insurer initially, and the Court of Appeal determined that this constituted a breach of principle of uberrime fide, which is utmost good faith. And the insured argued that they should be excused as the drastic amendment of their claim was incorrect, and the initial fraudulent attempt invalidates their right to recover regardless of later adjustment. The insurer can repudiate a claim if there is a breach of duty regarding good faith, or if fraudulent conditions are present, if the figures are amended later. The counsel argued that fraud in civil cases is proven on a balance of probabilities, and this principle is consistent with Section 17 of the Contracts Act and established the legal precedents. Next is the court's findings, where the adjuster's report confirmed the claim was exaggerated or grossly inflated, and fraudulent intent was inferred from the appellant's deliberate and intentional inflation of the claim to deceive the insurer. In terms of material time for fraud assessment, the critical time for assessing fraudulent intent was when the initial claim was submitted to the insurer on the June 24, 2013. Thus, the amendments to the claim made later before the trial were considered an afterthought and did not rectify the initial breach of good faith. In terms of breach of good faith, submitting an inflated claim breached the principle of uberrime fide, and the insured failed to rebut the presumption of bad faith and knowingly made false statements. Under Contracts Act, fraud was defined under Section 17 of the Act, which does not require proof of actual fraud as alleged by the insured. Therefore, the insured's actions fell under several subsections of Section 17, demonstrating intent to deceive. In terms of standard of proof, the standard of proof for fraud in civil cases is on the balance of probabilities, as clarified in the case of ZAHIYAH and Son Sendirian Berhad and Damai Setia Sendirian Berhad. This principle applies universally in civil claims, including insurance disputes involving allegations of fraud.
Thank you, ERSALINA. So moving on to the judgment of the court. So this case went through Court of Appeal and Federal Court, but the finding that we get is based on the Federal Court. However, both the Court of Appeal and also Federal Court concluded that exaggeration of the claim, which is the insured claim, amounted to fraud, and then fraudulent intent can be inferred from facts and circumstances which allow the insurer to repudiate liability under the policy conditions. Lastly, the appellant's claim was dismissed, which is the insured, and the insurer's decision to deny liability was upheld. So the insurers can deny the liability towards the claim. Next is the ratio decedent of the case, which is the reasons behind the decision of the court. So firstly, the court wanted to focus on why the exaggerated insurance claims and the fraud. So when an insured makes an exaggerated claim, fraudulent intent can be inferred from the facts and also circumstances surrounding the claim, even if the claim is later amended or the claim is reduced. So the critical time to assess whether the claim was exaggerated or fraudulent is that when the initial claim is submitted, not when it is amended before the trial. So basically, the insured want to amend the claim, the exaggerated claim, before the trial, even if the initial claim is actually higher, but the claim that is submitted before the trial is reduced. So the time to assess whether the claim was exaggerated or not is when it is submitted to the insurers, not when it is amended before the trial. So secondly, the court wanted to focus about breach of good faith. So the failure to act in uberrime fide, which is utmost good faith, is a fundamental breach of the insurance contract. An insured who submits an exaggerated claim knowingly makes false statement and breaches the principle of good faith, which is also and can justify the insurer's repudiation of liability of the claim. So for the third ratio decidendi, the court also focused on fraud under Contracts Act 1950, which is under Section 17. Fraud is defined in terms of intent to deceive, and it does not require proof of actual fraud, as used in some legal arguments. So a claim made with intent to deceive is actually already under the definition of fraud under Section 17. Or also, lastly, the court wanted to focus on standard of proof in civil claims. So in civil cases, including those involving fraud, the standard of proof is on the balance of probabilities, which means that court must be satisfied that it is more likely than not that fraud occurred based on the evidence presented. So balance of probabilities, which means that it is high if the possibility of them doing the fraud is higher based on the evidence presented, so that it is amounted to fraud. Subsequently, moving on to the analysis, which is the significance of the case. So firstly, what is important about this case? So the case talks about clarification of good faith in insurance, which is in this case they most importantly use the principle of uberi me fide, which is utmost good faith. So in insurance contracts, they must have utmost good faith, which emphasizes that both parties must act honestly, and also they must disclose all material facts when making claims. And secondly, the significance of this case is that what is the impact of fraudulent claims? So the ruling, the court decision, established that if an insured party inflates or exaggerates a claim, it creates a presumption of bad faith. So which is the principle earlier is utmost good faith, right? So if they make a fraudulent claim, then it can be presumed that there is a bad faith. So this presumption can lead to denial of claims, even if some legitimate losses exist. So for the next significance of the case, legal precedent on claim amendments. So what is the legal implication if the claim is later amended? So the court determined that amending a claim to reduce its amount does not rectify the initial fraudulent intent. So the timing of the initial claim submission is critical in assessing good faith. So like I said earlier, the critical time to assess whether the claim is fraudulent or exaggerated or not is when it is initially submitted, not when the claim is amended before the trial. So which means that even if they amend the claim, the initial claim already has fraudulent intent. So next, standard of proof for fraud. So this place clarified that in civil cases, which is also involving fraud, the standard of proof, like I said earlier, is based on balance of probabilities, also aligned with the provisions of Contracts Act 1950. Okay, moving on. The significance of this case also, we have more, which is guidance for insurers and insured parties. So the judgment in this case, which is the insurers can repudiate their liability, and also the insured claims is fraudulent, with fraudulent intent. So the judgment serves as a guideline for insurers on how to handle exaggerated claim, and also for insured parties, they need to be honest in their claim submission. And next, reinforcement of indemnity principle. It talks about how insurance policies are indemnity contracts, which means that insurers are only obligated to cover actual losses suffered by the insured, not inflated claims or not claims with exaggerations. So they are only liable for the actual losses of the insured, not the exaggerated claim. And then lastly, influence on future cases. This case, they start a precedent for future cases and future claims, and reinforce the importance of good faith, uberi me fide, within the insurance industry. So for the analysis part, I will also compare three cases with this ARW car workshop. So for the first cases, I will compare between ARW car workshop and also ZAHIYAH and Sons Sdn Bhd and Daman Setia Sdn Bhd 2015 1 MLJ1. So based on the case background, we already know ARW car workshop. The case revolves around an insurance claim where the insured inflated the claim, and then the insurer repudiated liability, citing that the claim is exaggerated claim. So for ZAHIYAH case, the case deals with fraudulent misrepresentation in a contract dispute. The claim involves a false representation made to induce the other party to contract. And then it also talks about standard of proof required to establish fraud in civil cases. And the legal issue in ARW car workshop is whether an insurer can repudiate liability based on an exaggerated claim, even when the claim is later amended. For ZAHIYAH case, the legal issue is that whether fraud in the civil cases must be proved in the usual way, and the standard of proof in fraud cases. So the decision of the court, like I have said before, the court held that in ARW, insurer was entitled to repudiate the claim. And then in ZAHIYAH case, the court confirmed that fraud in civil cases is proven based on a balance of probabilities, just like ARW car workshop, and it does not require proof beyond a reasonable doubt. It clarified that the standard of proof for fraud in civil cases is based on balance of probabilities. And fraudulent intent is in ALW, it can be inferred from exaggerated claim, even if there is later amendments. In ZAHIYAH case, fraudulent intent was established through false representation in the contract, but the standard of proof remains on balance of probabilities. And standard of proof, like I said, both cases talks about balance of probabilities, which aligns with Section 17 of Contract Act 1950. Moving on to the second cases, I'm going to compare between case Wong Cheong Kong Sdn Bhd and Prudential Assurance Sdn Bhd 1998, 3 MLJ 724, and ARW car workshop. So in the Wong Cheong Kong case, the insured, which is Wong Cheong Kong, took a life insurance policy with Prudential Assurance. The insured, which is Wong Cheong Kong, claimed the death benefit under the policy after the death of an employee. However, it was later revealed that the deceased was not covered under the policy and had made fraudulent representations regarding the relationship to the insured. The court ruled that these fraudulent misstatements by the insured invalidated the claim. So in ARW car workshop, it's based on the fire insurance policy. So the difference is that one is a life insurance policy and another one is a fire insurance policy. So for legal issue in Wong Cheong Kong, the legal issue is that whether fraudulent misrepresentation by the insured in the insurance application could lead to the repudiation of claim. So in ARW car workshop, they can repudiate the claim if it was initially inflated by the insured. So fraud in this case, in Wong Cheong Kong case, the court found that the insured fraudulent misrepresentation, specifically regarding the coverage of the employee, invalidated the claim. Just like ARW, the initial claim was exaggerated, so it amounted to fraud. So the decision of the court ruled in favor for Wong Cheong Kong, the court ruled in favor of the insurer, and also in ARW car workshop, the court upheld the insurer's repudiation of the claim, just both of them in favor of the insurer specifically. So for legal principle, fraudulent misrepresentation of false statements in insurance claims invalidate the claim under contract law, and in ARW car workshop, exaggerating a claim, an insurance claim is considered fraud and renders the claim void. Lastly, I will compare between case of Manifest Shipping Corporation Ltd and Unipolaris Insurance Corporation Ltd and others 2003 1AC 469. And I will compare this case with the LW workshop. So the case background in Manifest Shipping is that the claimant misrepresented the cause of damage to the insurer. They also failed to disclose critical facts that were material to the claim. For the legal issue, whether the insurer could deny liability on the grounds of fraudulent misrepresentation. So I've said many times about LW workshop is that the claimant defected the fire insurance claim, and then whether the insurer could repudiate liability. So fraud in Manifest Shipping, the court found that non-disclosure of material facts was a fraudulent act that justified repudiation. So basically, if they don't disclose about material facts of the case of the claim, if they don't disclose that, then it was a fraudulent act, and also they can repudiate the liability, the insurer. And in LW workshop, it's just the same. The insurer can repudiate the liability of the insurance claim, of the fire insurance claim. And then the decision of the court in Manifest Shipping is that the insurer was justified in denying the claim due to the fraudulent misrepresentation by the claimant. So legal principle is that the court enforced the principle that a failure to disclose material facts in an insurance claim amounts to fraud and also lead to repudiation of the liability. And in LW, exaggeration of the claim, even if amended, constitute fraud and violates the principle of good faith, obering, make, fide. And the standard of proof, like I said before, in Manifest Shipping Corporation, fraudulent misrepresentation in insurance claims must be proven by the claimant's intention to deceive the insurer. So in LW car workshop, it must be based on balance of probabilities, like I've said many times. That's all for analysis of the case. So finally, the conclusion. So for the first issue, submitting an exaggerated insurance claim, even if later reduced or amended, violates the duty of utmost good faith, uberi make fide, in insurance contracts. This initial exaggeration amounts to fraud, and also they allow the insurer to reject the claim. And then for the second issue, fraud in civil cases is proven based on balance of probabilities. So the insurer's deliberate overstatement of losses showed fraudulent intent under the law, under Section 17 of Contract Acts, and also it justified the insurer's decision to repudiate the claim. That's all from us. Thank you so much for listening.